Hey guys, welcome back to Entrant. I'm speaking on behalf of Law Times Journal, which is one-stop destination for Indian legal fraternity, and we'll be looking at weekly legal highlights. Starting with caste system is prohibited, but everyone is free to install caste-based display boards as they wish. Madras High Court. The Madras High Court held that every person private can freely display boards or other material irrespective of caste in his will as long as they are not obscene or derogatory. Chief Justice Sanjeev Banerjee and Justice R.K. The division bench of Hemlatha was hearing the petition of Amutan, who sought to instruct the defendant to remove the caste names used in front of educational institutions and shops and other establishments in Tamil Nadu on the basis of representation. In short, the petitioner raised the complaint regarding the caste names being used in relation to educational institutions, shops, and establishments. Next, does 50% reservation limit need a relook? Supreme Court asks states. The Supreme Court on Monday asked whether they were in favor of increasing the caste-based reservation by more than 50% in the 1992 nine-judge bench known as the Indira Sahane case. A five-judge constitution bench of the apex court implicated one of the many questions considering the constitutional validity of the Maharashtra law of 2018, in which the Maratha community was socially abolished with 16% reservation in jobs and admissions. The law was brought under consideration by the Bombay High Court in June 2019, but the reservation amount was reduced by 12% in admissions and 13% in jobs. Next, Jharkhand High Court took suo motu cognizance of the case of killing a family due to witch hunt. The Jharkhand High Court has taken suo motu cognizance of the disturbing killings of five members of a family in the state, including a 5-year-old child. The murders are reportedly done as a result of a witch hunt. The bench of Chief Justice Doctor Ravi Ranjan and Justice Sujit Narayan Prasad expressed displeasure over the case, saying that the evil of witchcraft still persists in modern civilized society. It is not only shameful but also raises a serious question on the entire system: how have such incidents happened in the present civilized society? The bench stated. The court has asked the state officials to file an affidavit clearly indicating the action they want to take so that such an incident can be avoided in the future. Next, multiple complaints by same party against same accused concerning the same incident is unacceptable. Supreme Court. The Supreme Court has held that multiple complaints by the same party against the same accused in respect of the same incident are unacceptable. Allowing multiple complaints by the same party in relation to the same incident, whether it is cognizable or a private complaint, is a crime will complicate the accused in several criminal proceedings. Next, the Supreme Court constituted a committee to consider steps for speedy disposal of check bounce cases. The Constitution Bench of the Supreme Court on Wednesday directed the formation of a committee headed by former Bombay High Court Judge Justice R.C. Chavan to take steps for speedy disposal of check bounce cases under Section 138 of the Negotiable Instruments Act to be considered. Next, the High Court of Punjab and Haryana denied protection to the couple living in contractual live-in relationship. The Punjab and Haryana High Court on Wednesday, March 10, registered its rejection on the new concept of contractual live-in relationship, supported by a deed in which the parties stated that their live-in relationship, marital relationship, is not. A division bench of Justice Arvind Singh Sangwan said that specifically indeed saying that it is not a matrimonial relationship is nothing but an abuse of the process of law as it is morally in the society cannot be accepted. Next, action must be taken against investigating officer who leaks private data of accused to the third party. Karnataka High Court. It is an important judgment. The Karnataka High Court has held that an investigating officer has no right to disclose the personal data seized from an accused's smartphone or electronic gadgets without the written permission of the court concerned. The High Court held that an investigating officer who leaks such personal data to a third party should proceed for disregard of duty or trespass. Next, limitation period for filing applications seeking appointment of an arbitrator, Supreme Court. The period of limitation for applying under Section 11 of the Arbitration and Conciliation Act 1996, hereinafter referred to as ANC Act 1996, would be governed by Article 137 of the First Schedule of the Limitation Act 1963 and will begin to run from the date when there is the failure to appoint the arbitrator. Next, Supreme Court issues notice to allow female candidates to join and train at the NDA. The Honorable three-judge bench comprising of Honorable Chief Justice of India issued the direction while hearing a public interest petition, hereinafter referred to as PIL, raising the contentions of violation of Articles 14, 15, 16 and 19 of the Constitution of India by not providing the chance to eligible and willing female candidates to join the NDA and providing them a chance to enroll, train and develop themselves in the NDA into future leaders of the Indian Armed Forces. Next, Kerala High Court issues notice on live laws plea challenging new IT rules. The Honorable Kerala High Court on 10th March 2021 issued notice to the central government on a writ petition filed by Live Law, a comprehensive legal news portal challenging the constitutional validity of information technology, Guidelines for Intermediaries and Digital Media Ethics Code, Rules 2021, herein referred to as IT Rules 2021. The petitioner asserted that the IT Rules 2021, so framed by the Centre on Feb 25, are arbitrary, vague, disproportionate, and unreasonable, and are imposing restrictions on digital news media and social media intermediaries. Next, Delhi Court extends interim protection for accused toolkit case. The Honorable Delhi Court on 9th March 2021 extended the interim protection from arrest to Shantanu Mulak and Nikita Jacob till 15th March 2021 in the toolkit document case related to the farmers' protest. The Honorable Additional Sessions Judge in the Patiala House Court also directed the Delhi Police not to take intimidating action against both the accused till 15th March 2021, the next date fixed for hearing. Next, the Wire and others moved the Delhi High Court challenging IT Intermediary Guidelines and Digital Media Ethics Code Rules 2021. Digital news portal The Wire has moved towards the Honorable Delhi High Court challenging the new rules made by the central government under the Information Technology Act 2000, herein referred to as IT Act 2000, to regulate internet intermediaries, over-the-top hereinafter referred to as OTT platforms, and digital news media. The petition has been led by Foundation for Independent Journalists, a trust which owns The Wire, founder and editor-in-chief of the News Minute, Dhanya Rajendran, and founding editor of The Wire, M.K. Venu. Next, jurisdiction of the NCLT over contractual disputes, Supreme Court. The Supreme Court bench, comprising Justices D.Y. Chandrachud and M.R. Shah, said that when a contractual dispute based on the grounds of mere insolvency of the corporate debtor, the NCLT under Section 65C authorized it to take jurisdiction over such matter. As per the judgment, the NCLT empowered to adjudicate the matter under Section 65 subsection C, considering the subject matter. The order also clarified that the NCLT is not restricted under Section 65 subsection C of the IBC solely because the IRP or the RP is responsible for the same. According to the order, there should exist a link leading to the liquidation of the corporate debtor. Next, the judiciary should be vaccinated towards the end, Bombay High Court. Bombay High Court, consisting of Chief Justice Dipankar Datta, witnessed an unselfish stance over the plea, looking vaccinating the judges, lawyers, and the court staff on a priority basis. Chief Justice Dipankar Datta remarked that while others are equally at risk, it would not set the right precedents for the legal fraternity to stand ahead of others. The court opined that the decision concerning priority vaccination should be by the executive, considering the position it holds. Next, Gujarat High Court proposes to prohibit social exclusion of women based on their menstrual status. The Honorable Gujarat High Court proposed to prohibit the social exclusion of women based on their menstrual status at all places, be it private or public, religious or educational. Honorable High Court proposed a set of guiding principles that the state government should follow to end menstruation taboo. While recommending the same, the Honorable High Court emphasized that all religions, including Sikhism, refer to a menstruating woman as ritually unclean. Thank you guys, and please subscribe to the Entrant for your weekly legal highlights.